All right.
Okay.
All
Good
right.
morning, everyone. Today is a great day for a Zoom call. We've got Sandra Borland on today to give us the layout of a listing agreement. And we will be recording this call. It will go up at the dashboard at homesmartconnection.com under the training videos tab within 24 to 48 hours after the call. And I will start to share my screen so Sandra can take it away from here.
Okay. Before we begin, a couple of interesting side notes that I think a lot of people, unfortunately, are not familiar with. Okay. If you are selling or buying a house for yourself, you are never allowed to do dual agency on that transaction. Okay, if you're selling your own house and a buyer calls and wants to see your property, you are allowed to do no agency with that buyer, but no dual agency. All right. Um, when you go to sell your house and a contract comes in on your house, you need to put your names or the name of your LLC, whatever you're using, on the contract. And next to your name, you should write seller is a real estate licensee in the state of Illinois. All right. Okay.
I
That
know
is,
all of a sudden your video came back on, Sandra,
it did.
except you're sideways.
And I don't know how to fix that, do you?
I do not. I do not.
All right.
And
Well,
I lost my share screen ability as well.
ay, 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 ay. Well,
I'm not
let's
sure why
see.
it's not letting me do
Maybe
that.
I've got I can see your screen.
You can see it?
Yes, can you
Well,
see
that's
it?
good. I cannot see it
Well,
myself.
that's a problem because maybe the others can't see it either. If can you, maybe I could share my screen.
Let's try this side by
All
side.
right. All
Maybe
Good
it
right.
morning.
changed my.
I can see it.
We can see
Okay.
the screen.
Okay. You can see the
Can
contract,
you
the
see the
listing.
Yes.
contract?
Okay,
Right
good.
Yes.
now, it's you, Deborah, and the contract on the side by side, but before that, it was just a agreement.
Huh.
Okay.
Okay.
So let me try this. Full screen.
Welcome to technology.
I know. It's lovely.
Yeah, I need to
Okay.
be able to see it so that I can scroll through it, but
Yeah.
I guess as long as they can see it, I'll be able to do it another way.
Why don't you see if you can let me share? Because maybe I could put my screen, because I've got that listing agreement up too on my other
Okay,
monitor.
sure.
All right. Let me know when.
Go ahead and try.
All right. Let's
Yeah,
see.
I've got multiple participants here. It says you're starting to share your screen, and there
Okay.
we go. You've got it.
All right. All right. So, um, there is some confusion about why we have, does everybody see line one and line two?
I
Ye-
do.
All right. Line one is the name of the sellers. So that would be your client's name. This, in this case, Sam Smith. Now, at line two, title is held by, that would be if Sam has an LLC, for instance. And a lot of people do that. In this case, Sam does not have an LLC. It's just in his own name. All right. The property address is 123 Main Street, Lake County in Cuba Township. I don't even know. I just made this stuff up, so I don't know if it's accurate or not. All right. On line five, we put the PIN number. Then we go down to the section concerning parking, and you would check off if there's a deeded parking space, assigned parking space, a limited common element, that would mean an unassigned parking space. If there's a parking space number, you would insert it at 8. And if that parking is being sold separately, in other words, you've got two PIN numbers, one for the house and one for the parking, you would insert that here. All right. I've been asked in the past, by agents in our office. If in fact a seller of a townhouse with unassigned parking can sell that parking. You cannot, because that parking is not deeded separately. So you cannot sell undeeded parking. All right?
Mhm. And please remember too that this is an interactive call, so you can unmute yourselves and ask questions as we go along.
All right. Now we go down to the storage space, and this applies primarily to condos. Is it deeded or assigned, a limited common element? If there's a storage space number, you would insert it at line 11. If there is a PIN number for that storage, you would insert it also at line 11. If there is a PIN number there, it is conceivable that you could sell that deeded storage space. All right. Now, the agreement term, this is typically the day I'm going to take this listing agreement at line 13, 319 of 26. It is going to expire 7/30 of 26. I got a call just yesterday from one of our agents asking me if we had minimums, a minimum term limit for our listing agreements. We do not at our office have minimum terms. Some offices say they will not accept a listing agreement for less than 6 months. We don't put any restrictions on you. We don't restrict you with how much you can charge. We don't restrict you with how long your listing agreement has to be. All right?
Sandy, I have a question.
Yeah.
This is Ted. And
Hi,
what
Ted.
if, yes, hi. What if, for example, that there's a cancellation guarantee on a listing, and that cancellation guarantee will go into effect? Does the managing broker have any say about a listing that does get canceled due to a guarantee, for example?
No, we don't interfere at all. That's
Okay.
entirely up to you.
Thank you
Okay?
so much.
You've got
Yep.
total latitude, Ted. Welcome, by the way.
Thank you. Mhm.
Um, let's go down to compensation because this is challenging for a lot of people. We do not offer co-op compensation on our listing agreement. Makes life simple. Let the other agent ask for what they want. When I go to take this listing, I tell my seller, Mr. and Mrs. Seller, what I'm going to show you right here on this agreement is what I need for my services. This 2.5% at line 18 includes all of my fees. Now, some of you, and rightfully so, charge an admin fee. Should you charge an admin fee, that is totally up to you and you are entitled to do so. That is your business. We don't interfere. That admin fee goes to you. Everything goes to you that you charge for commission, except for the $4.95 you're going to pay at the closing table. All right. A lot of you have asked for a cancellation fee. That is included here at line 20. Unfortunately, we are in a world where sellers are being bombarded constantly by information on the internet, and a lot of them get antsy when their houses don't sell in 3 days. We're coming out of a market where things were flying off the shelf and things were selling very quickly. I think the market has changed significantly. And so now, when we have these sellers who thought their house should have sold in 1 week, and now we're on week 3, now they're starting to make noises like they want to cancel and go to another broker. I think it's a wise thing to do to put this cancellation fee in when you take the listing. Should you need to, if you want to waive it at any time, we don't care. All right. If you want to collect it and you tell them you want to cancel, mister, as soon as we get a certified check at the office for this $500, we'll be happy to cancel for you. And know that if you're going to charge this, I will stand behind you and make sure we collect it. All right.
And then is there a transaction fee that's charged on that, Sandy?
I believe they're going to take 10% like they would on a rental.
Okay.
Right.
Mm-hmm.
Some of you also have an upfront fee. Our listing agreement does not cover a fee for an upfront fee. Have you had any people, Deb, ask you about that?
No, no.
Okay.
And I've never
I know
done
there-
it myself
There may
either.
be agreements out there, they've decided they're not gonna put one on this agreement for whatever
Okay.
reason. All right, so let's, one thing I wanted to point out at line 21, and I'm gonna read it to you. Full compensation is owed if a buyer introduced during this agreement closes within 180 days after expiration unless the property is relisted with another broker. Okay, that means if Sam Smith walks through this house today with his broker from wherever, and my seller slips him her business card and she cancels the listing with me next week, she can't go and sell to this guy on her own. She owes us a full commission. All right.
Okay.
All right. So any questions so far? Additional compensation. This is when an unrepresented buyer contacts you. All right. In the event the buyer is not represented by a licensed real estate professional, the seller agrees to compensate the listing brokerage with an additional, I'm charging them 1.5%. I'm being very generous here. The chances of me getting an unrepresented buyer are, at currently pretty high. I'm getting a lot of, I'm looking at the transactions coming in. I would say there's probably at least, I'm thinking a fourth of them are coming in with unrepresented buyers. All right. Now, a question that you need to discuss with your sellers is whether you are going to be conducting yourself as ever as a dual agent. This is a question I want you to, go over with your seller. We'll cover that a little bit later in the listing agreement. All right. This 1.5% would cover you if an unrepresented buyer comes and you do no agency. All right.
Sandy question.
Yeah.
Good morning, everybody. This is Sam. I'm the buyer. Uh, the I have problem with the line 25 and
Okay.
line 28. I believe both of them are the same person. If I have a listing and I have an open house, somebody walks in without the agent, immediately this person is unrepresented buyer.
Yeah.
And for my seller, they question me that, okay, who is the dual represented buyer? Because I don't know what does it mean. The buyer is not represented by anybody when he directly contact me to come and see the house. And then
Okay.
unrepresented buyer line 25 is the same person.
All
That
right.
is
There's a legal difference both to you, the listing agent, and to the buyer. If you're going to do dual representation, that's at line 28. You are giving up your rights to advise the seller if you're the listing agent. You can no longer advise the seller how much he can get for his house, what offers he should accept or counter. Under dual agency, you can't advise the buyer how much to offer on the house. Okay. An unrepresented, if you treat it as no agency and that unrepresented buyer comes, you can still advise the seller how much he can get for his house and how he should counter that unrepresented buyer's offer. I personally never ever do dual agency. I will, on occasion, I don't even like to show my listing to unrepresented buyers. A lot of people do that because they want to earn both sides of the commission. I think you need to be aware that when the state of Illinois comes into any real estate office and they're doing an audit, typically what they say is, bring me your last 10 dual agency transactions in your office. Because that's what they want to pick apart and scrutinize. So I think you have a lot less liability for yourself individually if you do no agency as opposed to dual agency. All right. When you decide whether or not you do no agency or dual agency, let's say you proceed with this unrepresented buyer under dual agency, have them sign it before you show your listing and make sure, and I know there's a dual agency form or an unrepresented buyer, no agency form out there that says signatures optional. That's fine for showing the house if you give them the no agency form and they're refusing to sign it. But when it comes to the contract, before you write an offer for them, you tell them we can't proceed unless they sign no agency. All right. So if you are the listing agent and you are going to operate either under dual agency or no agency, those forms must be signed either the day the offer is made or prior. All right. One or the other. Up to you. Sam, does that answer your question about,
Uh,
does that make
Not,
sense?
yeah, not really, but you can go on. I mean, uh, I have to just read it a few more times to see if there is any, I can find any difference between these two
Well,
individuals.
they may not explain it here very well. But there is a difference technically between the two on how you behave. Under no agency, you can still advise the seller. Under dual agency, you are not allowed to advise the seller or the buyer. Okay?
I have a
Okay.
question, Sandra. So,
Yes.
what if I showed someone a house as as an unrepresented buyer? So I gave them the no agency, they signed it,
Yeah.
but when they put in the offer, they decided to go with a, agent. What happens to the commission there? What if I have said that you're an unrepresented buyer, I'm going to charge you 1%, of the price. But now when they put in the offer, they signed the agreement with someone and,
Oh, you're saying they come with another agent?
yeah,
Okay. There's not a lot you can do, and especially you are representing the seller, number one.
yeah,
So if they come with an agent, you can always work on getting that commission later if you want. If you could say I'm procuring cause, you can
hmm,
still file procuring cause. The complication that we're seeing in the marketplace right now with procuring cause, I used to have probably 4 or 5 procuring cause cases a year. I had 0 last year. You know why? Because the co-op broker is no longer paying us. So I can't sue Century 21, or I can't take Century 21 to arbitration because they're not responsible for paying the co-op broker. It's the seller, and the
yeah.
seller is not bound by the code of ethics and not bound by the board. So they don't have to go to arbitration. The only way to get commission now when you're cheated at a closing in this situation would be to take the seller directly to court. That means you've got to hire a lawyer and pay court costs.
Oh,
So
what?
it's a lot more difficult to enforce procuring cause now.
Okay.
Okay. All right. So you notice here at line 29 that I put 0. I am
Mhm.
not giving myself the option of doing dual agency because I don't personally believe in it. Okay.
Yeah.
Now, there are some states in the United States that have actually banned dual agency, just so you're aware. And every time we go through a license law rewrite, um, we will, there will be somebody proposing that we ban it here. It hasn't happened yet, but it could happen at any time. And I think it probably would be wise if you do a lot of dual agency to get in the habit of trying out no agency. I think it's probably in your best interest. All right. All right, let's go down. Number 7 covers the situation
Sam,
where,
I'm
yes,
sorry to interrupt you. Can I just ask you a question? So if I do no agency, but I'm still writing up the offer for them and all of that, correct?
yes,
Okay. I just can't advise them on what price or anything.
correct,
Okay.
correct.
Okay.
All
Thank
right.
you. Uh-huh.
All right, let's say that while you have this property listed, the house was Sam Smith lived in this house when he listed it with you, but he moved out last week and he put a tenant in here. Surprise, surprise. What do? This section is only used if the seller decides to rent instead of selling during the listing agreement. All right. This is not a rental listing agreement. This is what if your seller surprises you and decides to put a tenant in. If you think your seller is going to pull a stunt like this, you probably need to fill out this paragraph to protect yourself. Okay, at line 33, not to be used as a listing agreement for rentals, but line 34, HomeSmart Connect receives a compensation equal to, what are you going to put in here as a punitive measure for them in case they go and rent this place on you? All right. Typically speaking, a half a month's rent for the listing broker. And at line 35, for multi-year leases, are you going to charge them extra if they get a 2 or 3 year lease? Okay. And then line 36, if that tenant buys the property, are you going to charge them a commission for that sale? All right. Paragraph 8, representation, that's you. I put my name in here as the seller's agent. At line 40, we are going to check is or is not related to the seller. I am not, in this case, related to the seller. Down to paragraph 9, consent to multiple representations. There are occasions where I have been informed by a seller that they thought I was only working with them and I could devote 24 hours a day to their needs. This paragraph tells them that I have other clients and I may represent other sellers. Um, I represent other buyers and hello, Mr. and Mrs. Seller, I'm going to do my best by you, but you're not the only game in town. Okay. It's just trying to set realistic expectations in the mind of that seller. All right. At paragraph 10, marketing authorization, let me scroll down just a bit. All right. In this case, I'm telling the world that I intend for this property to be on the standard MLS within 48 hours unless deferred to this date. I plan to have this property on the market by 3:20. I'm having my pictures done this afternoon and they'll get them back to me tomorrow. There's no reason why I can't be in the MLS by 3:20. All right. You've got a bunch of other choices here. At line 53, seller requests that the property remain on the private listing network until written direction from the seller is received. And then it will be submitted to the standard listing service. All right. Or the seller requests that the property be placed in the PLN for the duration of the agreement. Or seller requests the property be not to be placed in the PLN or the MLS for the duration of the agreement. Keep in mind, if you have a seller, and I had one once that said, I don't want to be in the MLS because I don't want anybody in the world to know I'm selling. You are not allowed to advertise unless your property is in the MLS in one way or another. All right. So you can't advertise for a buyer, so it's really tough to get a property sold. All right. So keep that in mind and explain to the seller if they come to you and say, please, I don't want they didn't even want to sign in this case. They didn't want to sign. They didn't want they just thought a buyer was gonna fall into my hands and I was gonna bring them to their house. So after 3 months of waiting, they decided to let me put it on the market and then it was sold in 3 days. Um, there is another question at line 59. Can an agent show the property to buyers while it's in the private listing network? That is entirely up to you. We have occasions where I see other brokerages and maybe some of our agents, I just haven't run across it, that are not allowing other agents to show while it's in private, but they show it and they put it under contract. Up to you. Totally up to you. I think you create ill will if you do not allow other agents to show and they hear that you're showing it. But that's, your business. We don't interfere. All right. Down
And the
in,
question,
yeah,
line 52, if the seller put a check mark that to put the property in MLS right away, the
yeah,
rest of the items are obsolete. I mean, because it's not in PLN and
right.
there
Exactly.
is nothing else. Okay, thank you.
All right. We need permission to put a lockbox on the door. I would recommend that every one of you take advantage of Central Lock because there is a record of who's been in and out of that house every time that lockbox is accessed. We have probably one or two occasions every month where we get calls where unauthorized access has occurred, doors were left open, windows were left open, heat was turned off, heat was turned on when it should have been off, and there was a combo lockbox on the door, so we have no idea who was in the house. Please, if we're lucky we haven't had any lawsuits on this lately, but sellers need to be aware. Sellers want to know that their house is secure. So I think it's in your best interest to invest at the very minimum of one electronic lockbox so that you can protect your sellers. Okay? All right, let's move on. This paragraph tells the seller what their responsibilities are, and that is providing timely access for showings, keeping the property presentable. Good luck with that. Respond promptly to agent communications, disclose ownership, liens, legal actions, municipal notices. I hate when I hear that the seller didn't tell their agent, and this happened in our office recently, that they hadn't been making payments on their mortgage for 6 months. And come to find out the property's under contract and find out that they're so upside down that they have to do a short sale. That puts us in a whole different ball game. And it's unfair to the buyer to have that sprung on them at the last minute. And please ask a lot of questions when you go on your listing presentation, please. All right. Providing all HOA documents is really important, I believe. In some cases, they don't have them. I don't know, people, after their closing, they shove things in corners and they can never find them again. But typically speaking, most sellers are provided a copy of the HOA documents at their closing so that they know what they can and can't do in the have any of you ever had an occasion where you sold a property and found out after the closing that there was something in those HOA documents that negatively affected your buyer? That's a really unhappy situation. When a buyer buys, let's say, a condo and he's thrilled and then finds out that he cannot have the dog that he owns in that condo association. That's why it's important to get those condo docs early on. All right. That could end up in a lawsuit, by the way, just so you know. Paragraph 13, fair housing. This is your standard fair housing paragraph. Illinois is far stricter with fair housing than nationally. So this gives you a list of all the protected classes in fair housing. We have to have initials at line 87, otherwise the listing agreement will be kicked back to you. All right. Minimum services. This is what is required by Illinois state law and the IDFPR. And there are brokerages out there that are not adhering to minimum services. If you encounter them, you should report them to the IDFPR. There's a company out there that I reported about 2 months ago to the IDFPR called HomeCoin. They do listings. What they do is they advertise on the internet that they will do listings for buy owners and they charge them a flat fee of like $250 or $300. The state of Illinois says that a listing agent, whether they're doing it for $200 or $1 million, has to accept and present offers and counter offers. Well, HomeCoin never heard of this, apparently. I don't know how they got licensed in Illinois, but they're not doing that. It is the listing agent's job to assist in developing, negotiating, presenting offers until an agreement is signed and contingencies are resolved. Additionally, they have to answer client questions about offers, counteroffers, and contingencies. You probably all have had plenty of experience with agents who just don't answer phone calls. It's pretty rude, but if you encounter this, feel free to report them. All right. Now we've got our dual agency paragraph at paragraph 15. I'm not going to read it all to you, but understand I have my seller actually read it and ask them if they understand what an agent can do and not do as a dual agent. When I am going on a listing presentation, I don't even give it an option. I pre-check no, because I don't ever want to be a dual agent. All right. Any questions so far?
Uh,
Let's go to earnest money. Oh, go ahead. Somebody was going to say something.
Sandy, I have a question. Sometimes I get stuck in a multiple offer situation,
Yeah.
and I know the listing agent is favoring another offer because probably that offer is from their own office.
Yeah.
And I have no way to find out if my offer was presented to the seller or not. Can I ask them to sign the last page of the contract?
You
That
can ask, but you can't enforce that. Here's what I've been told, and I know how frustrating it is. You can ask them to sign a rejection on page 14, or you can tell the listing agent. Now they've created a rule that if you ask the listing agent to put in writing that they have presented your offer, if they send you an email saying, I presented your offer on 3/19 at 8 o'clock a.m. to my seller, that is sufficient. So know that and if you have an agent that will not put it in writing, you can file an ethics complaint against them, Sam. All right.
Thank you.
You're welcome. All right, let's go on to earnest money. If it is your listing, be aware that we do not hold earnest money. You are more than welcome to have Chicago Title hold your earnest money. Chicago Title will move it if you're closing at a different title company. That's not a problem. There's a form you complete before the closing to have that money transferred. All right. You can find that form in broker forms in MRED. Deb, is it also in homesmartconnection.com? I can't hear you. She's
Yes, I
talking.
believe it is there as well.
Okay, sounds good. Now, I don't know whether all of you are aware that we have a relationship in the office with a smart title. All right. and it's kind of like a branch of Chicago Title. And if you decide that you want to use a smart title attorney, you would check line 131 and you'd write in the attorney's name. If you're going to use a different attorney and not a smart title attorney, you would check line 132 and insert the attorney's name, or you could put in TBD, to be determined, just so that you're aware. If you choose to use smart title and a smart title attorney, there is a possibility you could be paid at the closing table directly rather than the check coming back to HomeSmart and HomeSmart paying you. It might get you your money, 24 to 48 hours earlier. Okay. But there are hoops you've got to jump through. You must have your file totally approved if you're going to use Smart Title. You have to have your commission statement turned in and approved at least 10 days in advance. There's, I believe, a document that you have to sign guaranteeing that you're going to follow the rules with Smart Title. Okay.
Mhm.
And if all these things don't fall into place, you're not going to be paid at the closing table anyway. All right.
And starting this past Tuesday, we started introducing one of our smart title attorneys, Dan Palmer, who came into the office on Tuesday.
Oh,
And
nice.
every Tuesday from now on, we're going to have a smart title attorney to come in
Okay.
on Tuesdays to introduce themselves so they can get to know us better.
Very good.
Mhm.
Very good. Okay. Does everybody here know that there are happenings on Tuesdays in Arlington Heights office every Tuesday, right, Deb?
Right, at 10 o'clock a.m.,
And every Wednesday in St. Charles.
at 10:30 a.m.
Yeah, and I think Libertyville is doing something typically too, right?
Well, he has a difficult time getting in Antioch is Joe Prindle on
Okay.
Mondays.
Okay.
But it's been small attendance, so we
Okay.
need to increase attendance out there on Mondays in Antioch.
And you guys can go to any or all of them, actually,
Right,
and you learn something every time you go.
right.
Okay. So if you have earnest money come in on your listing, and every now and then we have people just dropping off checks. We don't take it. We have to send it back. So make sure when the contract comes in on your listing that the correct box is checked on the contract, that you
Mhm.
checked other. Now, the other broker can also hold the earnest money if you prefer. Not a problem. Let's go down to paragraph 17. Um, in this particular case, my client does not have any solar panels on the premises. So I've checked line 140. We are finding more and more people got talked into buying solar panels. I would say about at least 80% of those people have a lease on those solar panels that typically travels 30 years with the property. Okay. So if your client has solar panels, we need to know. Now, at line 41, are they owned outright by the seller with no remaining financial obligations? Probably 1% of the sellers own those solar panels. More likely at line 142, the solar panels are subject to a financing agreement with the remaining balance of. So you need to find out how much is left on that lease and what the balance is, or on that purchase agreement. All right. Will those solar panels at line 144 be paid in full by the seller no later than closing? Will they be assumed by the buyer? And are they rented with a current monthly payment of? We have seen cases where the seller had to pay off the panels to get the house sold. It all depends upon the lease agreement that you have with the solar panel company. All right. If any of you have any comments about this, I haven't had any myself, but I've seen a couple deals in our office get affected by this. And ask as many questions as you can. Get documentation if you have a seller that's got a contract. All right? Any questions? Paragraph 18, home
Sandy,
warranty.
I'm sorry,
Yes.
Sandy, we just had a solar panel purchase. We purchased a home with solar panels. Also ask the seller if there is a fee to the buyer to transfer. And
Oh,
our seller was not aware of that, and it's very common, I guess, but so we wrote that in, once we were aware of it, we went back and asked the seller to pay for that. So
okay.
on the side, there is usually a transfer fee, and it'll show up when the buyer logs in to transfer. So that's just
Wow.
good information to
How,
ask about.
how much was that transfer fee?
It was 350.
Okay.
Oh,
It's
wow.
not horrendous. I thought we were talking thousands, but thank goodness it's only 350.
Right, but there are two ways for my buyer to become qualified to even take on that lease. And we had an existing 23-year lease on the solar panels that my client
Wow.
had. And they either had to run their credit, the solar panel company, or pay a fee to not run their credit to see if they
Wow.
qualified. So then we had to go back to the lender and say, is it okay to run it? It's a soft pull of their credit.
Okay. All
So
right.
we chose to have them do that because we got the approval from our lender, but also it was a big ordeal. I would say we learned a lot. My attorney and obviously myself, the listing agent who didn't know a lot. And also, the listing agent was also able to become an authorized user on the account during this time. So he could
Wow.
get questions. He could answer questions,
Okay.
and documentation. So it did delay a little bit just because they were not familiar. So now that I know this, it's something, obviously, if you're taking a listing, you want to get that contract immediately from
Yeah.
solar panel company and then read through and make note of all the fees so you can advise the buyer's agent.
Yeah, and keep in mind, um, some people will not qualify. Some buyers barely qualify for their mortgage, let alone an additional payment for the solar panels. Okay, so that's going to knock a certain number of buyers out of the ballpark. All right. Paragraph 18 covers home warranty and disclosures. It's up to your seller whether they want to put a home warranty on. If you've got a house that's older with systems that are aging, may be advisable to put a home warranty on to make it more attractive for buyers. Okay. You can read paragraph 19, paragraph 20 on your own. Let me go down to paragraph 21, seller's disclosures. And we have not been real strict about this in the past, but I want us to be better about it now. If you're taking a listing today, I want you to have the sellers complete all of the disclosures today. I do not want you to delay because a buyer has every right to see those disclosures before they write an offer on your property. Okay, all too often I hear people selling their listings and they've never given disclosures to anybody. That contract is not worth the paper it's written on if the buyer hasn't been provided those disclosures prior to signing that contract. All
And
right.
I see that so often. They
So
don't have the disclosures, and I tell them, can you please upload the disclosures so that I can send you a complete offer package?
exactly. Now, there is, in case you didn't know, there is a place on the MLS to upload those disclosures, documents. When you're uploading your listing, I typically have my disclosures uploaded before I activate that listing. All right. If you don't know how, go, Christine at the front desk can show you. It's very simple. All right. Any questions about disclosures?
I have a question. Is there any additional disclosures for townhomes or condos?
No, same
No.
disclosures. Same
Okay.
disclosures for each. All right. Now, if this was a rental listing agreement, you have an additional disclosure, and that is the flood disclosure. All right. Now,
Okay.
when you're listing a rental, that flood disclosure. Now, some people say, I don't need a flood disclosure because we've never flooded. The law says you must have 2 flood disclosures. One, and it covers the entire property, the driveways, the parking garage, the basement. So let's say you're on the 20th floor of a condo building, you still need a flood disclosure because maybe the parking lot has flooded on occasion. Or even if it hasn't, you still need the flood disclosure to tell the prospective buyer that it has never flooded. Okay? Now, that first flood disclosure that's filled out by the seller when you list the property has to be given to the tenant prior to them signing the lease. All right. The second flood disclosure is embedded in the lease, and it basically ascertains that they have seen the other flood disclosure. Okay. Now, the only, excuse me, boards that have the newest flood disclosure embedded in the lease is Main Street's flood leases. All have it. Main Street also has the compensation built into their lease. In other words, for the tenant's agent, they have the request for the tenant's agent to ask for payment for their commission. All right. NASBAR does not yet have it on their lease. They have the flood disclosure, they do not have the commission on their lease. You, because I belong to all of the boards, are allowed to use any of the leases that you want. Okay. So I've got all the leases, the most current leases uploaded to broker forms in MRED. They should also be in homesmartconnection.com. All right.
Mhm.
Let's go down to taxes, assessments, and association fees. I recently had this rather surprise. Had a listing go under contract, and my seller had told me there was no special assessment. And it turns out that there was a special assessment. She's just kind of a dingbat who didn't know she was paying a special assessment. Um, Ask for all the recent correspondence when you're taking a listing from the association so that you get this right. Is this property subject to a special assessment or a special service area? Do all of you know what a special service area is? Yes, no? Special assessment is a situation where the association says to your seller, we need new roofs, so we're gonna special assess you $50 a month for the next 3 years to pay for the new roof. So that will be in addition to your regular association fee. A special service area, on the other hand, is more common when your client is buying new construction and the builder didn't want to put the cost of bringing in all the utilities into the cost of the house. Instead, they're passing it on as a tax to the new home buyer. All right. So the price of the house looks very attractive. They're able to keep the cost of the price of the house down, but you're going to have, in addition to the house mortgage payment, you're going to have your regular property taxes, and then you're going to have the special service area assessment. And that typically runs with the house for, I've seen it go for 40 years, your SSA. All right. The only time this becomes really complicated is when you're selling a property in a subdivision that had like 4 phases, for instance. I sold a townhouse in Volo that was purchased by my seller in phase 1. There was an SSA on the property, all right, that ran for 40 years, all right. Now, when the builder got to phase 4 of this subdivision, all the utilities were paid for with all those SSAs that they passed out in phase 1, 2, and 3. And the people who bought in phase 4 have no SSA. All right. So when my seller went to sell, my phase 1 seller, he had this $150 SSA a month that he has to pay, but the people who were on the market in phase 4 have no SSA. So my seller had to make the choice to make his property more attractive, had to pay off his entire SSA. All right, so ask the questions when you're listing the property, so you're not surprised later. All right. We have a paragraph here, condominium homeowners association, is or is not. We need the association name, contact name if possible, and a phone number. Now, the next paragraph is association assessments and fees. What does that association assessment and fee cover? Click off everything that is possible. Some associations have a master association as well. Be aware of that. The MLS will ask you if there's a master association. Let's look at the taxes. The most recent real estate tax for this particular house was in 2024, and the tax was $7,500. Now, some counties have their act together much quicker than Cook County. Cook County is just now starting to think about the 25 taxes. Other counties are more on board and have their 25 tax bills ready. All right. Is there a homeowner exemption, a senior freeze exemption, or another kind of exemption on this property? Ask your seller what exemptions they've got. If your seller's not sure, go to the tax assessor's website and find out for yourself. Okay. Let's go down, and if there are any other addendums that apply to this listing agreement, like a short sale addendum or a foreclosure addendum, you would check this box at line 227 and list all the documents here on line 228. Are there any questions so far? No?
No.
Okay. Let's get down to, we have a personal property rider. This is everything. I have the sellers check all this off, or you can pre-check it with what you know and ask them to read it over and ask them if there's anything else that needs to be added, or is there anything that needs to be taken away? And I say, Mr. and Mrs. Seller, looking at your property right now, is there anything you're looking at in here that you've decided you can't live without, that you're going to take with this house sale? And I've had people tell me, I'm taking the refrigerator because my dad gave it to me right before he died. And I'm like, well, okay, but then let's replace it. And so that's what we did. If they have to take the dining room chandelier because they love it, they spent 6 months looking for that chandelier before they bought it, then my advice to them is, let's take it down and replace it right now so that the buyers don't fall in love with that chandelier. Because once they see it, they want it. Okay? All right, so you're going to check off all the personal property that belongs with this house. There's an anti-fraud warning. We've seen people get scammed, so make them read this, make them sign this. This tells them don't accept wiring instructions from anybody except your attorney, and do it over the phone, okay? People get emails saying do this, do that. We've had people, especially buyers, be robbed in the past. So be very careful. And sometimes once they've got your money, it's almost impossible to get it back. All right, the scammers. Affiliated business arrangement disclosure. This tells the seller that we have a relationship with Smart Title, and they need to be aware of that. Doesn't affect them one way or the other. Even if they're not using Smart Title, we want them to sign that we disclose to them that we have a financial interest in Smart Title. All right, we're done. Any questions?
Sandy, two questions.
Yes.
First of all, this contract doesn't have anything for the houses that they have a auto charger, electric charger, the EV charger for the electric cars.
Then we could add that down, other items included on the personal property page.
Other item, okay. Or we can do it on the attorney letters probably.
Yeah.
Let the buyer knows that.
Yeah,
has
I would that is a definite plus for a property. So I would definitely write it in here and put it where the buyers can see it in remarks, because
Okay.
that could be a real reason that they'd want to buy here because it's already done for them. What else?
Beautiful.
And
And
what
then
about the solar panels as well?
Exactly. Exactly.
that's the plus plus. Sandy, my other question is there is nothing illegal about asking the buyer a copy of the driving license to find
No,
out what is their exact name.
no, not at all. Now, sometimes people get real funny when they want to buy things incognito. In other words,
Exactly.
especially investors, sometimes they want to operate under an LLC and they don't want the world to know what their business is. Just be aware you cannot sign in the name of the LLC. All right. Every corporation has a signer for that corporation. So even if somebody submits an offer XYZ LLC, Mr. Smith, Mr. Sam Smith has to sign in his name as the signer for that LLC. All right.
And
Okay.
there's also the FinCEN rules now as well.
Um, well, all right, what do you know, Deb, about the rules as pertain to the
Teresa
real-
Haish came in and gave us a presentation about FinCEN rules because buyers who are paying cash,
Yeah,
we need to know who they are and their address and their email and phone number and everything now because there are people who come in with cash purchasing homes and
yeah,
they're actually trying to funnel the money through the purchase in order
yeah.
to wash the money.
But now, is this the realtor's responsibility or is it the title company's responsibility? Bill?
It falls on the closer who at the title company,
Okay,
and they can go to jail. And
all right.
so it's become really a big issue right now because many closers don't even want to be closers anymore because they're
Wow.
so scared.
Yeah, because it falls on them. This is
Right.
Bill and I were talking about it, and he said, we don't
Right.
need to worry about it. It's on the title company. But you know what makes life simple is page 14 on the contract has a place for name, address, and all the information for. Please do not finish up, don't sign off on this document, the 8.0 contract, until page 14 is completely filled out on both sides.
Right.
Okay?
Both sides of the transaction.
Absolutely. All
Right.
right.
Yep.
This will make everybody's life easier.
Which means you have to get the buyer's address and phone number.
Yes.
They are going to want it one way or the other. The title company is going to want it
Yes.
one way or the other. So make them do it now. It's
right.
easier for the title company.
Just address, no email, no phone number, correct?
It would be best if you could get it all.
Get it all if you
And give
can.
it to
All
everybody.
right.
Yes, give it
Yeah,
to
maybe-
everybody. Everybody
maybe-
has everything now. Yeah.
Because sometimes for their privacy, they hesitate to
Well,
give their.
the
Yeah,
world
they
is
hesitate because they don't
changing.
want you to steal their client.
Right. The world is changing. You've got to explain to them there are new federal regulations that require this information, especially if it's a cash transaction.
Especially cash, yes.
Yeah.
Yep.
Sandy, the reason I asked you for the getting a copy of driving license in my last transaction, 3 days before closing, the buyer sent a copy of his driving license to the title company to prove his identity. And
Yeah.
then the title company came back. He said, "Oh, this makes Mr. XZ as a middle name is the XYZ.
Oh,
So
gee.
now you have to change all the paperwork from beginning to the end
Wow.
to add his
Wow.
middle name, and he signed it."
Yeah,
But
I agree that it would have been preferable to find that out early on, but probably the attorney is the one that really needs to verify that even more than you.
yes, but what we did because it was 3 days before closing, they came up with the addendum that they added the middle name and they said this person
Yeah.
is this person, and the buyer and seller sign it, and we send it to the lender, we send it to the title company and everybody else. then they came down and said, okay, now we can close it.
Yeah, we have a lot of last minute complications that occur. For instance, adding another buyer on in the 11th hour just prior to closing because
Correct.
the buyer needed help qualifying for this mortgage, it turns out. So a lot of times we have buyers being added. When that happens, be aware that you need to have that new buyer sign that buyer rep agreement as well, if you're the
Yeah,
buyer's agent.
yeah.
Okay.
Yeah, it's good. Yeah, it's good to be very uh, a little rude or honest at the beginning and kind of look at the license and see if he has a middle name or something else.
Exactly. Also
Not
be aware you are going to get calls on occasion, strange calls that people who ask you to list a lot that they have. Very often it is in McHenry County. For some unknown reason, the scammers really like vacant land in McHenry County. I don't know what their end game is, but we've had two occasions in our office where fraudulent sellers have contacted our agents and asked them to list a property. One time we caught it before it went live. Another time we were actually on the market for a considerable amount of time until we got a call from the real owner of the property saying,
Wow.
you have my property listed and it is
Wow.
mine, not anybody
Wow.
else's, and I don't want to sell it. They actually showed up at our office and said, I can prove to you I own this property and it is not for sale. So, these scammers are showing driver's licenses with the actual name of the owner. And I don't know where they're getting these documents, but use forewarn because sometimes that's the tip off, especially if you've seen that they've got a lot of convictions. Um, be very careful. If you're suspicious, run it by me. We'll talk about it together. I don't want you to be taken advantage of. All right? Because you spent a lot of time um, working on this listing, and if to find out after you've done all this work that you wasted your time, that it's non-existent, is heartbreaking. All right?
All right.
Any other questions?
One more, just can we go back to the parking section because it
Yeah.
says city, so that means it's not valid. You don't need to fill it up or put
Oh,
NA if you're
all right, let's go back. Let's see where it was.
in the beginning. Good.
Okay, we'll get there. All right. We're almost there, right?
Yeah.
All right. All right, right here. All
Yeah.
right. Now, what were you asking?
I was saying the parking and the storage space, these two are only valid for city like Chicago or like,
There are, no, it is for the suburbs too, anywhere. Anywhere it's if it's a condo building or
uh-huh.
a townhouse, yes, this could be used in the suburbs as well.
Okay. So if we have a garage parking, you just do the indoor, right? That's what you need to do?
Yeah, but a lot of times that parking space in the garage, it has a PIN number,
Okay.
okay?
Okay.
Sometimes it doesn't. If
Okay.
it just has a number, you put the number in here, all
Uh-huh.
right? Okay?
Okay. Okay. Sounds good. Thank you.
Any other questions?
Can you expand how far in the agent is related to the seller buyer to disclose?
I would like any relationship disclosed. If there is any possibility, see, here's the reason for that. Um, if this is your brother, your cousin, you're going to be most loyal to them, and you can't be loyal to two people. In other words, I'm going to protect my family no matter what. And so I'm going to advise them. I can't be totally impartial when it's a member of my own family. Okay. So I would say, even cousins, you should disclose. All right.
Better to be safe than sorry.
Better to be safe. All
Yeah.
right.
Mhm.
All right.
Do you have to do it even when you're a buyer's
Yes.
agent
Yes,
for the cousins and all that too?
you should.
You
You
should.
Okay.
All right.
How about in-law side?
What?
In-laws, like for example.
Yes.
In-laws,
Same thing.
in-laws.
Same
Yep,
thing.
Okay.
yep.
All
Your
right.
brother-in-law, your mother-in-law. Yep.
Yes.
Yeah.
All right.
Okay.
Any other questions? All right. Have a wonderful rest of your March.
Does anybody have any suggestions they would like to discuss in next month's call? Please email us at trainer@homesmartconnect.com with any ideas or suggestions that you have for Sandy's next call.
All right. All right. Oh,
Very
I see.
good.
I'm sideways.
Yeah, you are sideways.
Ah, I have to figure out how to fix that. Thank
I
you.
love it.
All right. Bye, guys.
Thank you so much, Sandy. Appreciate all
Thank
your
you,
help.
Sandy. This was
Awesome.
amazing. Thank you.
Yes. All right. Have a great day, everyone.
Bye.
Bye.